Hello and welcome to episode 7 of my Employment Law Snapshots. In this episode I'll be talking about fighting at work, llamas, meerkats and crocodiles. This week's bumbling nonsense was inspired by one of the best employment-related newspaper headlines that I've read for a couple of years. Meerkat handler who glassed zoo colleague in Christmas party catfight over a llama keeper wins her unfair dismissal case. That's right, your ears aren't deceiving you. This was a case about a meerkat handler who was sacked after attacking her llama keeper boyfriend's former girlfriend at the work Christmas party. She won her unfair dismissal claim because the Employment Tribunal decided that both women should have been sacked. However bizarre the story is, it does raise a common problem for employers who give different disciplinary sanctions to employees who are involved in the same incident, which I'll look at in this week's case. Now be warned, the details of the case involve fighting and swearing, but it's by no means a llama drama ding-dong. This week's case is called MB&A Limited against Jones. Mr. Jones was employed by MB&A and they hosted a work function and told staff that normal standards of behaviour would apply and any misbehaviour would be subject to the company's disciplinary policies. Mr. Jones went to the event along with another employee, Mr. Battersby, and Mr. Batterby's sister. This is where things started to go wrong. According to the Employment Tribunal's judgment, Mr. Jones was kneed in the back of his leg by Mr. Battersby. He reacted by licking Mr. Battersby in the face. Mr. Jones was also seen with his arms around Mr. Battersby's sister, prompting a second knee to Mr. Jones's leg from Mr. Battersby. Mr. Jones responded by punching Mr. Battersby in the face. Mr. Jones then went to a club and Mr. Battersby waited outside and texted Mr. Jones 7 times, threatening to rip his bleeping head off. However, Mr. Battersby didn't carry out his threats. Mr. Jones was dismissed by MB&A for his behaviour, which was viewed as gross misconduct. However, Mr. Battersby was only given a final written warning. Mr. Jones brought an unfair dismissal claim in the Employment Tribunal and he won. The Employment Tribunal decided that the decision to dismiss Mr. Jones but only give a final written warning to Mr. Battersby was unfair because it amounted to an unreasonable inconsistency of treatment. MB&A appealed against the finding of unfair dismissal and MB&A won. The Employment Appeal Tribunal said that when it comes to considering different treatment between employees, the Employment Tribunal should have focused on the legal test of whether MB&A's decision to dismiss Mr. Jones fell within the range of reasonable responses that a reasonable employer might have taken. Instead, the EAT said that the original Employment Tribunal had lost sight of this test and had wrongly focused on how Mr. Battersby and not Mr. Jones was dealt with by MB&A. Consequently, the EAT said that if it was reasonable for MB&A to dismiss one employee, the mere fact that MB&A was unduly lenient to another employee was neither here nor there. The EAT said that there can be some situations when it might be unreasonable to treat 2 employees differently in truly parallel circumstances arising from the same incident, but that this would be rare. The EAT commented that it considered that the circumstances between Mr. Jones and Mr. Battersby weren't sufficiently similar to be considered as truly parallel. This was because Mr. Jones punched Mr. Battersby at a work event when he knew that he would be subject to MB&A's disciplinary rules. However, Mr. Battersby sent threatening text messages, but he wasn't violent. He didn't see those threats through. As such, the circumstances weren't truly parallel. Therefore, Mr. Jones's dismissal was considered to be fair. This case shows that an employee can't simply rely on any leniency shown to another employee arising out of the same incident, as long as the employer can show that their decision to dismiss was within the band of reasonable responses. But don't forget, there can be some rare occasions where the offences committed by the 2 employees are so similar or truly parallel that leniency towards one of the employees could lead to a finding of unfairness for the employee who's dismissed. This appears to have been the situation in the case that will now be forever known as Llama versus Meerkat. When more than one person is involved in an incident of misconduct, it's always worthwhile taking some advice before any decisions about sanctions are taken. And finally, over the years, I've advised a lot of businesses in relation to their recruitment policies, but thankfully I don't practice law in Indonesia. That's because last week I read a bizarre article which reported that the Indonesian government's currently going through a recruitment process for a new prison that's going to be built on an island. However, rather than trying to recruit human prison guards, they've decided in their infinite wisdom to use crocodiles instead. According to their anti-drugs agency, crocodiles will make better guards because they can't be bribed. The recruitment process has involved various visits to a number of Indonesian archipelagos to find the fiercest crocodiles available. I wonder what would happen if a disgruntled crocodile didn't get the job. Could it sue the Indonesian government? Presumably, it'd have to find a really good litigator. Gator, crocodile, get it? Sorry. Thanks for watching. I hope you've enjoyed it. If you want to subscribe to our YouTube channel for more updates, click here. If you want to follow us on our Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you just want any more information or help, please go to our website by clicking here. And of course, all of the links are below. Once again, thanks for watching and see you next time.